Hello everyone, I'm going to discuss with the topic that is unpaid seller as per section 45 of the Sale of Goods Act. It's a very important topic and interesting topic also from the examination point of view. So unpaid sellers usually having certain rights are available to him because he is called as an unpaid but still has some rights are available in front of the judiciary. So justice is given to him because he is an unpaid seller. What will be his rights? How much he can exercise it? That we have to discuss. So as per the section 45 of the Sale of Goods Acts, the seller of the goods is deemed to be an unpaid seller. First ground is there when the whole of the price has not been paid or tendered. Second ground is that where a bill of exchange or other negotiable instrument has been received as a conditional payment, that is subject to the realizations thereof, and same has been dishonored. So that is, first you have known that his cost or the consideration has not paid wholly, or not tendered means not offered also, that is section 45 says. And second ground said he will be called as an unpaid because when a bill of exchange or other negotiable instrument has been received as a conditional payment. So other negotiable instrument, maybe he might have gotten check, and check usually people are giving, the buyer will be giving, not a go and get it from the counter. No, he will issue the check post dated, that is subject to the realizations thereof, and the same has been dishonored. Subject to the realization means whatever the date is mentioned in that check, that is a negotiable instrument, so on that day only he will get the money from the bank. Or the same has been dishonored means the same check has been dishonored means bounce the check, dishonored a check. This is means it cannot be honored from the bank because he might have not an sufficient amount in the bank. So that is section 138 of the Negotiable Instrument Act. That's called and bounce of the checks or the dishonor of the check, because it cannot be, check cannot be honored because of the insufficient fund he is having in the bank. So that is called unpaid. He is a seller but unpaid. His consideration amount has not been paid. Now, how will you come to know he is a seller or unpaid seller? There must have some distinguishing characteristics must have. So what is his characteristics? How you can assume that he is an unpaid seller? Now we see the first characteristics is, first he must sell goods on cash and not on credit, and he must be unpaid. He must sell goods on cash. He should take cash from the buyer and not on credit. He should not give on credit, and he must be unpaid. That is, he was not being paid. That's the first characteristics. Second characteristics we see, he must be unpaid either wholly or partly. So his consideration amount or the cost of the goods has not been paid fully or partly. Nothing has been made. So even if only a portion of the price, however small or small part might be remaining to be paid, right? So he is deemed to be an unpaid seller. Where the price is paid through a bill of exchange or other negotiable instrument, the same must be dishonored. So he said either wholly or partly it was not been paid. Suppose even if it is a small portion of the price, suppose as a token money he has given the buyer, maybe a small part is also still remains to be unpaid, then also he will be called as an unpaid seller because the whole of the price has not been paid. So when the whole of the price is paid through a bill of exchange or other negotiable instrument, the same has been dishonored. So this negotiable instrument he has been used, and that was dishonored. If it was bound, then definitely he cannot be called as a seller, because he will be still called as an unpaid seller because his consideration amount has not been paid. Then third, characteristics, we will see it that he must not refuse to accept. He must not refuse to accept payment. He should not refuse it when tendered. So when this buyer might have offered him an payment of the goods, but he refuses it, then the price has been tendered by the buyer, but the seller wrongfully refuses to take the same, he will be ceased to be an unpaid seller. Because buyer has requested him to take the payment, receive the payment, accept the payment, but he was not accepting it. That means he wrongfully refuses to accept it. Then he cannot be called as an unpaid seller, because of course the offer has been made by the buyer. So definitely you cannot be called as an unpaid seller. So this is your characteristic. The three characteristics must be there. Then the seller will be called as an unpaid seller. Now we will go to the rights available to an unpaid seller. What is his rights is available? Now it's a very interesting to be discussed on the right part, that is right of lien, that is section 47. So the very typical word that lien, I think your general meaning will be, everyone is knows, that means right to retain in goods. That is a lien you have. This lien is also been used in some other, subject matter also. Lien, the word is used. Sales of goods section we are using the right of lien, that means right to retain the goods or the possession of the goods. This is called section 47, which has been made under section 1930 Act. Now what is the lien? It says we will discuss. So lien is the right. It is the right. So that's right is what? Right to retain possession of the goods and refuse to deliver them to the buyer until the price is paid or tendered. So an unpaid seller in possession of the goods sold is entitled to exercise his lien on the goods in the following cases. We will see it. What are the grounds, on what circumstances he can still retain the possession. So this is the lien called. Lien is the right, that is, so you can retain, you can keep it with you, the possession of the goods. You are selling the goods, but possession will be holded by you only, the seller, because he refused to deliver them. Seller will not deliver to the buyer because the price is not been paid or tendered. Offer is also not been made. So that's why. So the unpaid seller in possession of the goods sold is entitled to exercise his lien on the goods in the following circumstances. So he can have the right to retain the goods with him, so until the payment has been made. Now what is the cases we are going to discuss is the first case, where the goods has been sold without any stipulation as to credit. So your goods has already been sold, but without having any condition as to credit. Because you have sold it, but you have not made any express condition that you are giving it on credit. So of course you are not going to give it on credit. This is the circumstances. The first circumstances, you will be called as an unpaid seller and having the right to have the retain the goods of the possession. So this is the lien we call exercise under this circumstances. And secondly, where the goods have been sold in credit, but the term of credit has expired. You might have sold the goods on credit. That means you have given a credit, but the term of credit has already been expired. Right? Then you can retain the goods with you. That is a lien you can exercise. And the third right we are having it when we can exercise, where the buyer becomes insolvent, even though the period of credit may not have yet expired. Your credit period is going on. It has not been expired. And the buyer become insolvent. So when buyer become insolvent, then how he can pay the price, consideration amount, he cannot pay it. So that is why the unpaid seller can retain the possession of the goods with him. So this is the three circumstances or the cases where he can exercise his rights. Now this is the right we are saying he can exercise it, but not always the thing that he can exercise only. Always he can exercise this right. Is it possible? It may not be possible. So he can also, lose this right also. When you will lose this right. So when lien is lost, we will see. This right to having the possession of the goods may be lost when the lien depends on physical possession of goods. So if you are having a physically in possession of the goods, that is your lien will depend. You must have your physical possession of the goods. Then you can exercise the right of lien. Once the possession is lost, the lien is also lost. If you are not having the possession with you, so you will also lose the right of lien. So the unpaid seller in goods loses his lien in the following cases. When you can lose the right of lien, so that means you cannot exercise your right. First point is there, when he delivers the goods to a carrier. When you have delivered the goods to a carrier, that means who will carry the goods for the, buyer. So that's why you have given it to a carrier where he can carry the goods to the destination of the buyer. So that is why you have already given on a carriage or other bailey for the purpose of transmission to the buyer without reserving the right of disposal of the goods. This is the first circumstances where the unpaid seller will lose his right of lien. First they say if you have given it for carrier or other bailey, that means who is having a possession of the goods on behalf of you, he might be having for the purpose of transmission to the buyer. So it is not the carrier you have given, but it is somebody else who are holding these goods, because he is also going to make a transmission. That means he will carry the goods to the buyer or reach to the carry the goods and delivering the goods to the buyer. So that is called a bailey he is having, but there was no right reserving disposal of the goods. So he was not having the right of disposal of the goods. He must be only in the carrying the goods to reach to the destination of the buyer, but he was not having a right of disposal of goods, means he cannot dispose the goods to the buyer. In that time, the unpaid seller will lose his lien, that is right of lien. He will not have it because already give it to somebody else. The second circumstance is where the lien will be losing when the buyer or his agent lawfully obtains possession of the goods. Buyer or agent or his agent has already legally or lawfully they have obtained the possession of the goods. That means possession is with the buyer or his agent. Then how can you exercise the right of lien? It was not to your reach, right? So the goods are not to your reach. So unpaid seller cannot exercise this right of lien. And the last circumstance is where this right of lien will lose when the seller expressly or impliedly waives his right of lien. So seller himself, that is unpaid seller, he has made an express words or by conduct or by action, he has given up his right of lien. So that will be called as waiving his right of lien. That means he cannot exercise his right of lien. So this is the three cases or the circumstances where the right of lien of the unpaid seller will lose it. So he cannot exercise his right of lien under these circumstances. So this right, that is why it's a very important right. So right to retain the goods or the possession of the goods with the buyer, it is important from the examination point of view. And the rest of the right, that is I will discuss in my next video, because it is a very landy topic also, and in landy and as well as very important and very interesting topic, that is right of stoppage in transit, that I am going to discuss in my next video. And also we have to also distinguish, differentiate it, right of lien and right of stoppage of transit. Then we have to see how also the right of stoppage in transit can also lose, when he can exercise, when he cannot exercise it. This provision also we are going to study in my next video. So till then, keep watching this video till the completion of this. And if you are new to it, don't forget to subscribe to my channel, and whereby I can get your motivations and I can make new videos for you and useful videos for you for examinations, and I will not waste your time at all. So till then, keep watching and see you in my next video.